Act. Second. Third is whether the coercive machinery under the CRPC can be availed under the DV Act. This is third test to be applied for examining 482.
Who is for the respondent?
There are, it is appearing online in my matter.
Please, Milord, I am for the respondent in 12 and 12 point.
Yes. Milord, before I take your lordships to other aspects of my argument, I will just invite your lordship's attention first to section 482.
That's what we are reading.
Yes, and Milord, I must also point out the view that your lordships take may also have impact on Milord maintainability of revision, as also Milord 406, 407, etc. That will create a complicated situation where magistrates.
So, as we understand your argument is the provision enacted to prevent abuse of process of any court. A court-based court under the CRPC. That's your basic argument.
That is fundamental argument, but that's not
argument. And even otherwise to secure the ends of justice.
There are three components of 482. One is for enforcement of the orders under the code, which is directly linked to the code. But second and third component, Milord, is not linked to the code. And therefore it is my submission, Milord, the fundamental, Milord, argument that I'll be advancing is that it's for the court which is to be seen. And the court in this case, I will show, Milord, provisions of the DV Act as also the CRPC. Lord, may I take your lordships to series of provisions under the DV Act?
In this case, we need not go into the wider question. What happens when reliefs under DV Act are claimed in civil proceedings?
Yes. Not going to that, Milord, your lordship may just keep aside for the moment.
That's a totally different question. Yes. Not going to that. Yes. We are here because as far as first matter is concerned, it was before the learned magistrate.
Yes.
Section 12 complaint.
Other matters also may not arise.
No, other matters also before the magistrate.
I suppose, Milord, there is similarity of Milord fact situations. Yes. Please have a look at, Milord, the provisions of the DV Act.
Yes.
But there are not many provisions which are relevant for our purposes. Your lordship may start from the definition.
Yes.
Milord, the first provision is section 2I, as your lordship, Milord, observed, the definition of magistrate. Magistrate means judicial magistrate of the first class, or as the case may be, the metropolitan magistrate exercising jurisdiction under the Code of Criminal Procedure in the area where the aggrieved person resides temporarily or otherwise, or the respondent resides, or the domestic violence is alleged to have taken place. Now, Milord, having seen this, please have a look at a couple of provisions under the CRPC Act. It starts from section 6.
That is a chapter 2.
Yes.
So there is like 4 kinds of courts under the CRPC.
Yes, but important aspect is 6 Milord gives those category of courts. Your lordship may just see the section 9, section 11 and section 16. Section 9, state government shall establish a court of session for every session division. And then, Milord, subsequent subclauses, your lordship, Milord, what is important is establishment of the court and under the court. Then, Milord, section 11, courts of judicial magistrates in every district, not being a metropolitan area, there shall be established as many courts of judicial magistrate again to be established. So, Milord, even judicial magistrate first class is a court established under the court. That's something relevant. And then, Milord, your lordship may see section 16. For metropolitan areas, the courts of metropolitan magistrate. In every metropolitan area, there shall be established as many courts of metropolitan magistrates and at such places as the state government may, after consultation with the High Court by notification. So, establishment of the court under the court. This is something that, Milord, is extremely important for our purposes. And that's what, Milord, the term magistrate, Milord, defines under section 2I of the DV Act. Now, have a look at, Milord, clause G. Domestic violence. Domestic violence has the same meaning as assigned to it in section 3. So, my lord, reference to section 3 becomes necessary. Now, my lord, section 3 brings out, my lord, something very interesting or very important, relevant for our purposes. Definition of domestic violence. For the purposes of this act, any act, omission, or commission or conduct of the respondent shall constitute domestic violence in case it, Lord, please see A, B, C, D, harms, injures, endangers the health, safety, life, limb, or well-being, whether mental or physical, of the aggrieved person, or tends to do so, and includes causing physical abuse, sexual abuse, verbal and emotional abuse, and economic abuse. This is the Lord B. Harasses, harms, injures, endangers the aggrieved person with a view to coerce her or any other person related to her to meet any unlawful demand for dowry or other property or valuable security. C. Has the effect of threatening the aggrieved person or any person related to her by any conduct mentioned in clause A or clause B, or D. Otherwise injures or causes harm, whether physical or mental, to the aggrieved person. Without explanation, I will not bother you, Lordship, for the present. If your Lordship see A, B, C, D, these are essential criminal acts. They are essentially criminal offences as recognized under the IPC or any other provision of some other statute. So, my lord, the very trigger for the activating the machinery under the DV Act is what is defined as the domestic violence, which is essentially a criminal offence. That cannot be missed, but there is something more important with respect to that. But now, please have a look at section 5. Duties of police officers. Lord, I said that one of the tests is whether the machinery of the police or police machinery can be availed under the DV Act or not. Duties of police officer, service providers, and magistrate. For police officer, protection officer, service provider, or magistrate who has received a complaint of domestic violence is otherwise present at the place of an incident of domestic violence, or when the incident of domestic violence is reported to him, shall inform the aggrieved person. But what is to be informed? Clause E is important. Of a right to file a complaint under section 498A of the IPC whenever relevant, and proviso equally important. Provided that nothing in this act shall be construed in any manner as to relieve a police officer from his duty to proceed in accordance with law upon receipt of information as to the commission of a cognizable offence. So, my lord, the moment domestic violence is alleged, which I have shown, my lord, is essentially a criminal offence, my lord, the
This court has no doubt taken a view that essentially it's a civil case.
no, my lord,
Just one second, just allow us to complete. Now, we are on very limited issue. Legislature in its wisdom has conferred powers of entertaining section 12 complaint on courts of magistrates. So prima facie, what we may say appear to be correct, because basically 482 comes into picture to prevent abuse of process of court. Court means court under this act. So by that logic, in fact, 125 of CRPC against the civil remedy, the sense
145 is the best example.
145 is the best example. There are civil remedies. So, therefore, prima facie subject to hearing what your opponent says, there may be a power vesting in the High Court to entertain a petition under Section 482 for quashing Section 12 complaint on the ground that is abuse of process of law, and second part is otherwise to secure ends of justice.
Ends of justice.
The second part may apply because under this act, relief can be sought even against the members of the family of
Precisely.
the
And that's where there are cases where
members of the
lodgings
family of
have
husband. Now, take a case where the larger dispute, the main dispute between husband and wife is settled, but it is not settled with mother-in-law. Then, under the second part, court can exercise power. The matrimonial matter is disposed of,
yes.
and therefore exercise power under 480, 82 and quash the complaint. Because there may be dispute regarding residence, etc. If husband has taken care of by providing maintenance or house or whatever it is. So, prima facie, you seem to be right subject to hearing here, that there is a power. And we are confining ourselves to Section 12 complaint before a magistrate.
Yes, my lord, but I must point out there are not many provisions under the act, my lord, which substantiate, my lord, what I am trying to.
So, therefore, what we are trying to tell you, whether we should be going to the question whether any criminality is involved in the complaint under Section 12. Once we accept as a proposition that
It is the magistrate's court.
it's a court under the CRPC, only question you'll have to argue is considering the nature, beneficial legislation, nature of the beneficial legislation,
I fully see.
whether the court should entertain a petition under 482.
My lord, therefore I said, my lord, I started with
as a state. So ultimately, what should be the parameters?
I made two parts of it, my lord. One is whether, as a principle, 482 will be available or not. Lord, 482, if your lordships will not hold that 482 is
Therefore, you
available.
consider on the second part, what should be the parameters
Parameters. I understand that.
looking to the nature of the legislation, the object of the legislation.
I fully see, my lord.
For
And
example, we'll give an example. Suppose wife files a petition under Section 125 for maintenance. Legally speaking, you are right that even those proceedings court can entertain 482. But the question is whether court should exercise that power.
Lord, desirability and maintainability are two different issues. My lord, while examining the issue of maintainability, your lordship may, my lord, first, my lord, take a view on that, and then your lordship may say, my lord, lay down the guidelines for that. How careful or cautious the court should be, or circumspect, etc. That's a different thing. But my lord, this is not the only provision. I will show, my lord, so many provisions under the act. Please have a look at, my lord, for that purpose now.
No, if prima facie you are accepting your submission that 482 will be available, you better concentrate on the second part of it.
No, my lord, my difficulty
Right.
I must tell your lordships. There are a few high courts which have taken Madras High Court judgment, very well written judgment, though my lord, reasons I don't agree with. Taking a full court, my lord, of the Madras High Court, taking a view that, my lord, 482 is not available. And therefore, my lord,
Bombay High Court full bench is to the contrary.
Bombay High Court full bench, my lord, has reversed your lordships.
Correct.
Therefore, my lord, even today, my lord, I came across the judgment of the Bombay High Court, where perhaps that full bench judgment was not shown. Matter is again referred to the larger bench.
That's the beauty of system.
Yes,
Sitting here, I can always take contribute.
Milord, just one thing, I'll wait my turn and I'll take my submissions at the end.
You refer to larger bench, that's my lord. So, my lord, it will be in larger interest if your lordship will not deal with the issue of maintainability first. And then, my lord, other aspects, certainly we will not assist your chiefs. Please have a look at section 9. It shall be the duty of the protection officer, Lord, please see clause B, to make a domestic incident report. Lord, please mark this word domestic incident report to the magistrate in such form and in such manner as may be prescribed upon receipt of a complaint of domestic violence and forward copies thereof again to the police officer. But I said that there is repeated reference to police officers seeking their assistance, etc. Police officer in charge of the police station, and your lordship has seen proviso that police officer will not be will be free to lodge, will not initiate investigation, etc. Police officer in charge of the police station within the local limits of whose jurisdiction domestic violence is alleged to have been committed, and to the service providers in that area. Now, the next provision is clause G of the same section. to get the aggrieved person medically examined. My lord, this is now leading to, my lord, medico-legal cases kind of, my lord, arena. To get the aggrieved person medically examined if she has sustained bodily injuries and forward a copy of the medical report to the police station, and the magistrate have jurisdiction in the area where domestic violence is alleged to have taken place. Then H. Please see clause H, my lord. To ensure that the order of monetary relief under section 20 is complied with and executed in act.
Please, my lord.
We'll continue in the next. It should be treated apart. Next Tuesday we'll continue.
Well,
Are you stretching it to the extent that though the complaint is maintainable in the court of magistrate, the High Court is powerless under 482? Is that going to be your submission?
Lord, I will try and keep it to the. I understand your lordship has said securing the ends of justice and to prevent abuse of process, but I'll try and show that 482 is not the correct remedy. There are other remedies there entitled.
No. We are not on that. There may be other remedies. But can you say that applicability of 482 is completely excluded?
Yes,
What
my,
should be the
my,
scope? What should be
I
the
wanted
scope
to
for
say-
interference will be different. Looking
I
to the
wanted to say one thing, my lords.
nature of the registration, etc.
I wanted to say one thing, my lords. I dispute the submission that the magistrate is a criminal court for the purposes of the DB Act, my lords. He's a designated court. I make my submissions on that to assist the court.
Submission. That's right.
Please, my
All
lords.
right.
I didn't want to interrupt my learned senior.
All right.
I'll be there
Just
physically.
wanted to know what is the basis of your submissions. So
My
just-
written submissions are also there. I'll assist the court to the best.
Second session, your lordships will not be.
we have fixed matters. So
Very well.
this will continue as partnered matter in the morning on next Tuesday.
My lordship, may I submit 12.1, my lordship? My lordship, matter was not compromised, but it has become infructuous because, my lordship, against interim order, my lordship, that traveled all the way to Supreme Court, my lordship. Against that interim order, my lordship, final order is already passed by the lower court, my lordship.
But who appeared for the petitioner?
I have the judgment, my lordship. My lordship,
Let us see. Show us which order you are playing upon.
my lordship, in the paper book, P2 is the interim order and this is the final order, my lordship.
There appears to be so.
Pending for Tuesday plus, let me verify plus if
I'll just verify it. It appears to be so. Where the complaint itself is disclosed.
I would have instruction done so plus not to be
Yes, sir. So this will also remain other matters.
I apologize for being there
The
virtually.
lordship's
today.
kind permission. The lordship is taking some of the matter at 2 o'clock. So other matters won't be taken.
That depends on lawyers. They are present. We don't know.
No, because I tell okay, we'll wait.